Hi, this is Rahul Reddy. This is live from Houston, Texas. Today is Tuesday, as we are live every Tuesday at 5 p.m. Central Time. I'm Rahul Reddy. Along with me is Emily Newman. We are partners in Reddy & Newman PC. We have established our law firm in 1997. We're still doing exclusively immigration. Emily?
Thanks for joining. I also, in addition to posting on Reddy & Newman's website, rnlawgroup.com, post on immigrationgirl.com, which is my blog. So if you have any questions that we don't get to here today, you can certainly ask them there. Also on Twitter, at rnlawgroup or at immigrationgirl.
Yes. Emily, there are a lot of burning issues right now as the quota has been, we have already filed the H1B quota. We started receiving the receipt notices, and the USCIS last week said they have finished the data entry system. Does it mean that we're not going to get any receipt notices? Have you got any rejection in the lottery notices yet?
All right, I would say we're getting very close to the end of receipt notices. We did not receive any today, which is typical for a Tuesday. We did get a number of them yesterday, and I did provide the updated statistics yesterday on immigrationgirl.com. So the only ones that we received yesterday were non-advanced degree. We have not received any advanced degree receipts in a couple of days. So I think tomorrow, my guess is probably going to be the last of the receipts coming in, if we get any at all. And we should be expecting the returned petitions to start arriving anytime now. That continues generally into mid-June. So I think we're getting near to having the non-selected petitions returned back to us.
That's right, Emily. It's been a little bit delayed compared to last year with regards to getting the receipt notices and also rejection notices. But as we have seen as years, that sometimes the rejection notice might span all the way to about 2 months. So you might still expect the rejection notice all the way to July of 2018. Emily, have you gotten any approvals in the new quota? Have you gotten any RFEs in the new quota?
More RFEs than approvals, but yes, we've received both. We are receiving approvals and we are receiving RFEs pretty much daily now. Nothing out of the ordinary, I would say, in the requests for evidence, nothing out of ordinary in the approvals. They are still getting approved for 3 years as long as the documentation supports that 3-year approval. On the RFEs, it's typically is it a specialty occupation? If there's third-party placement involved, is there an employer-employee relationship with the right to control? In the event that optional practical training or curricular practical training, STEM OPT, was used, we are seeing requests for evidence asking about maintenance of status during the F1 time, especially where the person used up 12 months of practical training and then went back to school at the same degree level and is now using CPT. We are seeing requests for evidence on that, questioning whether F1 status was maintained, which is important because now we have a proposed draft memo that deals with unlawful presence in student visas. How does that interplay with these requests for evidence?
So for those people who have used the CPTs, particularly the day one CPTs where the university have issued, they are in great danger, especially with the memo issued by the USCIS. What the USCIS memo is indicating, it's a proposed memo which will be finalized pretty soon, is that if the USCIS determines that the student has violated the legal status, in this case, for example, if the CPT was being issued for a student who has completed the master's degree and obtained the OPT and used the OPT, and then he moved on to day one CPT, the USCIS is telling the day the CPT started, from that day they will count the undocumented stay in United States. That's going to have a rippling effect on the students, because if the person is out of status for 180 days, there is a 3-year bar that the person cannot enter back into United States. And if they are out of status, that means that if their CPT has been more than 360 days, then the bar is for 10 years. Now, previous to the memo, the USCIS said that the day the status has been denied, the undocumented stay will count. But now they're telling it's not the day that status has been denied, it is the day that you have taken the CPT. Now that's a very dangerous precedent that the USCIS is establishing with this memo. I hope we can counter that because the comment period for that memo is still there. We expect to give a draft to a lot of people so that you guys can comment on that on the draft memo, Emily.
Right. So this is not a final memo yet. We have until June 11th to submit comments. Assuming that it does become final, it would take effect from August 9th. So stay tuned for more information on that.
I mean, another is asking this question with regards to why is that HR 392 is not moving anywhere? As I just want to make sure that people know that the HR 392 removes the per country quota limit. So if the per country quota limit is removed, the Indian nationals which are backlogged to about 11 to 12 years on EB2, and for those people who are going to apply right now, they're going to be almost 100 years backlog. If they remove the per country quota limit, the priority dates might move all the way to 3-year backlogging, and the next year it probably is going to be only 1.5 year backlogging. Why is this HR 392 moving any forward? The bill that has been proposed in the House that removes the per country limit, which has the strongest support from both sides of the Congress.
Right. It's shocking that a bill with hundreds of co-sponsors is never even brought to the floor for a vote, no debate, nothing is happening on it. And that's the case with multiple immigration-related bills. And it seems to be, Paul Ryan's, I guess, argument for not doing anything is that Trump won't sign it, so why bother? I think that makes the House leadership look bad, because at least if they pass something,
they have done their duty.
They've done their job, and let Trump go ahead and veto it. Then Trump looks like the bad guy, not them. But it's just I don't know, it's just politics more than anything else. And we see it all the time. There's been so many immigration proposals since, 1996 was the last major?
The major legislation passed was 1985. It was a Reagan era. In 1996, they did pass a minor legislation, but the major legislation came in 1985. And the IRA Act, which was being passed in 1996, which became effective on April 1st, which I wouldn't consider that it's a major immigration legislation, but it has some minor impact on the immigration that was passed, and the effective date was April 1st of 1997. That's when our office was formed 21 years ago. We have not seen any immigration bill passed that has significant effect on the immigrants. So it's the Congress is not doing, and that the Parliament is not doing anything. And we probably need to keep on following up with the congressmen. Please write letters to the congressmen to support the 392, HR 392, and write letters to the senators.
One of the questions that we get a lot on here is about the 240-day rule.
Yes.
Let me start out by saying you should never allow it to get to 240 days.
Can you explain what a 240-day rule is, Emily?
Right. So in the event that you have filed an extension of your H1B with the same employer, not a transfer, but an extension, and while it's pending, your I-94 expires, the 240-day rule says that you can continue working and remain in the country for up to 240 days past your I-94 expiration to give sufficient time for processing delays, RFEs, all of the steps that have to be done in order to get the approval of the H1B. So with these long processing time that we're experiencing...
Where is the long processing time, Emily? If you pay $1,225, the processing time is only 15 days.
Exactly.
What are you speaking about long processing time? Is the premium processing suspended right now?
No, it is not for extensions for sure. So there's really no reason to ever risk crossing 240 days. Please file in premium processing or upgrade to premium processing. Don't get to that point. We've said again and again, don't even get to the point where your I-94 expires. There's no reason for that. you should file well in advance so that in the unfortunate situation where a denial occurs, your I-94 is still valid. You have the opportunity to refile, you have the opportunity to file an appeal, you have the opportunity to change status. There's so many different strategies you have for moving forward from that. But once your I-94 expires and you get a denial after that, you're really out of luck. There's not a lot of options for you to get back into status other than leaving the country.
Anybody who is telling you that premium processing is going to get you the denial, premium processing is going to get you the RFE, that is the biggest lie in United States right now going on with the H1B extension. Don't believe it. That's a way that some of the people wants to make money, because when you guys get into trouble, bigger trouble, they're going to make money. Don't believe in that. Please pay the $1,225 to the USCIS so that you can avoid paying money to the lawyers. The chances of you getting an RFE or denial is the same as in the regular processing. So we don't understand why people will wait until 240 days. You have the premium processing, pay the extra $100 to $225. Why sit at home? Emily, I want to address the big thing that it is affecting the immigrant community at this point of time is the STEM extension. As you already know, that a lot of the students who come into this country to study the STEM degrees, and they get the OPT after they complete their master's degree or bachelor's degree, then they're eligible for the STEM extension for a period of 24 months. Now, in your Immigration Girl blog, and then you pointed out that in January of 2018, though you published in March of 2018, that the USCIS updated that the STEM extension people cannot work at third-party location. As you know that the whole world is working at third-party location. The reason what the USCIS cited was that it is because the employer cannot control the employee when they are working at a third-party location. As you have seen, when you go to the airports, we see the CBP, Customs and Border Protection people, they're not working at their locations. And in Texas, all the doctors that are working at a different location because hospitals in Texas cannot employ doctors. But they put a restriction not for the OPT, they did not put the restriction for the H1B, but only for the STEM extension. They put it out in the website. Have you seen the implementation of it? What is the negative effect? Is there any way to get around that one?
So as of now, I've not seen anything from USCIS where they questioned third-party placement in a request for evidence, like on a 765 RFE or an H1B RFE, knock on wood, so far. What I have seen, people have commented on my blog about it, is that some schools are sending out notices to their students letting them know they basically have 2 weeks to find another job that does not involve third-party placement, or they're not going to be able to continue their STEM OPT. We've also seen the situation where sometimes the employer where the person is placed at is willing to hire the individual and have them work while they're on the STEM OPT because they don't want to lose that person. So it seems that the market may be reacting to the publishing on the USCIS website, even though there's nothing technically official on there. There was no regulatory process done. It didn't come from ICE, even though ICE is technically the one that is responsible for implementing all of the STEM OPT regulations. So it's quite surprising how this whole thing is unfolding, and we just don't have a lot of information right now on what the effect will be going forward.
We have seen some universities rejecting the 983. We have also have one university send emails to all their students that if you're working at third-party location, you have to cease working within 2 weeks and update the 983. But I think so it's growing a little bit, this really major concern for a lot of the STEM extension people. But we will keep on updating on our articles and on our videos what's going on, Emily.
All right, Siva has a question. I saw this on Twitter last week where a lot of people were tweeting about the potential for the visa bulletin to move forward for EB2 EB3 India substantially in the next couple of months. Why is that? Why are they going to push it forward now when they normally do it later in the summer?
See, previously, for those people whose priority date was current who filed the adjustment of status, they used to adjudicate the 485 application without any personal interview. Since March of 2017, the Trump administration came and said, well, we need to interview everybody who's going to get the green card in the employment-based immigration. Now, previous to those applications filed of March of 2017, about 98% of the cases that we file adjustment of status used to get adjudicated, approved most probably, without going for the interview. Now, for those cases that we filed in March of 2018 or March of 2017 or afterwards, they have to go through the interview process. The problem with the interview process is, Emily, the USCIS is very busy, and some of the districts are very backlogged, and a lot of these officers who are accustomed to seeing the family cases and other cases, they're not accustomed to see the employment-based cases, so they are unable to adjudicate these cases. There's a lot of backlog. Since the Congress mandated that the administration has to approve 140,000 green card applications when they are pending, since the USCIS is unable to adjudicate the 140,000 applications, there is a chance that the Department of State will look into the numbers that are coming in and might move the numbers so forward that it might move a lot more forward, but we don't know how the Department of State is going to act. If you recall, Emily, in 2015, there was the Department of State has moved the priority date, but then they went back and they did the correction in September of 2015. And the same thing happened in 2007, in July of 2007, that they moved the priority date all the way to current, but the State Department and the USCIS came back. But as a compromise, we were allowed to file the adjustment of status. But we have to see how the State Department is going to act, because when they see the 140,000 numbers are not going to get filled out, the State Department might take some stringent actions by moving the priority date very forward.
All right, we have a question about already the next year H1B cap for 2019. If your OPT is expiring, let's say in February 2019, and you file your H1B in April, does that qualify for you to stay in the country?
It depends on, is it February 1st or is it February 2nd? For the people who are on OPT, they do have a 60-day grace period that will allow them to stay in United States. If the April 1st you file an application, let's say for example your OPT is expiring on February 5th, the 60th day falls before April 1st. So if you file an application on April 1st, you can stay in United States, even though you can stay in United States, but the cap gap is not applicable to you. That means that you cannot work until the H1B is approved and after October 1st of 2019. Now, for those people's OPT which is expiring on or after April 1st, they fall into a thing called cap gap. That means that if their H1B is selected in the lottery, they can work, but for those people whose OPT is expired and they fall into the 60-day by April 1st, they cannot continue working, but if their H1B is selected in the lottery, they can stay in the United States.
All right, I think Anil's probably listened to our videos before, because he has a question about, kind of why is it that we recommend those that are on an H4 EAD can file a perm in I-140 if their employer is willing. Does it help with getting continued H4 EADs? Is that why we would have that?
There are multiple reasons why we recommend H4 EADs to file for the green card application. First is that if they have used the H1B before, and now if they are on the H4 EAD, they can, when and if the H4 EAD is being taken off, you would be able to go back to the H1B, and then you would be able to extend the H1B beyond 6 years. So that's one way of looking at it as an advantage. Now, if you have never been on H1B application, H1B before, now you are an H4 EAD. As such, I don't see any great advantage for them to file a labor certification I-140. It might be a little bit advantage because later on when they get to the H1B, they can use the I-140 priority date. But since their spouse already has the previous I-140 priority date with a previous priority date, I don't see a great advantage if a person did not hold the H1B before. But as such, there is no disadvantage in filing the labor and I-140. But if they have used up the H1B, some part or all part of the H1B, and if they are an H4 EAD, we advise them strongly to file the labor and I-140 because that's the only way when the H4 EAD has been taken off, you can use the H1B beyond the 6 years of H1B. Emily, there are a lot of questions coming on EB1. A lot of people saying, okay, now EB1 priority date is current one, and that people want to file a EB1A, EB1B, EB1C category. Is it that easy that just because I'm a manager or I'm the architect of the software, am I eligible for EB1 just because I'm an architect of a software?
Probably not. I mean, there's no set requirement on that you have to be in a certain job or do a certain thing, but it's a pretty high bar. So yes, we have a lot of interest in it right now because obviously EB2, EB3 is so backlogged, but not everyone is going to qualify for it. That's why it's EB1 because it's first preference. It's the cream of the crop is basically what it's
so particularly EB1A, if you're just an architect, maybe definitely not. But let's say, for example, if you're an architect of a software program called WhatsApp application that was sold for $18 billion, and you have all evidence that you are the person who was the architect of WhatsApp application, yeah, definitely. I think so that should be considered to go for an EB1. Or if you're a Facebook architect or something which is significantly very good, then you might consider, particularly if your architect that you have designed the softwares, maybe in artificial intelligence, got a lot of patents on it, that might be considered. As a bar from our office, I think so that if there are no patents for 3 or 4 patents, then I would not like to entertain the EB1As. Now there is also that pops up, Emily, is that can I apply for multinational executive, which is EB1C category? I exhausted, I'm in the 8th year of H1B, I-140 is approved in EB2, can I do the EB1 manager, EB1C, that multinational manager, am I qualified for it?
Mm-hmm. Yeah, I mean, that is kind of the extension of the L1 requirement. So number one, you have to have worked outside the U.S. for 1 year as a manager or executive before you can qualify, and there has to be a qualifying relationship between the company in the United States and the company overseas that has hired you or employed you for that 1 year period. On top of that, it's again, not that easy of a bar. Not every single manager is going to qualify. Not every single executive is going to qualify. So it is not something that most people who already have an EB2 I-140 are going to qualify for if they've been on an H1B. Yeah,
the question that pops up is that, hey, can I go to Canada or India, work for 1 year and come back here and get that green card immediately? It's not as simple as that you just go to work in India for as a manager and you come back here and it's not that easy. It's a little bit more complex, and the chances of getting success is not that easier as what people think though.
Right. Just again, working as a manager or an executive or being called a manager or executive isn't enough. It's got to be very high up in the company, the foreign job and the U.S. job. Not your first line supervisors, managers, they're not going to qualify.
And the other question that pops up, because all the people are backlogged, the EB application, employment-based applications, can I just buy a house with $500,000 and get a green card?
The EB5 category.
That's right.
Well, the EB5 is not that easy either. there are, it's the $1 million visa or the $500,000 visa if you meet certain requirements. That investment is very stringent about what will qualify, very restrictive on where the money can come from. You have to document that all the money, the whole money trail of where you got the $500,000 or the $1 million. And we find that there is, you may get the initial conditional residence, but when it's time to remove those conditions to get a permanent green card, a very low percentage of people actually get it because they determined that the investment really didn't qualify, you didn't actually create the 10 jobs or whatever all of those requirements are. So it's not as easy as just getting $500,000 and investing it somewhere and getting a green card for sure.
Typically, we see a success rate for well-documented things of only 15% statistics. So, and that too, it has to be, and there's a lot of restrictions. New memo came out last week, disabling a lot of those people who are in the pipeline, particularly those people who are in the real estate. Prashant and Ilango has the same question, Emily, is that my I-94 is expired. I filed for the H1B extension. It's 240 days. Can I still work?
No. Once you cross 240 days, you cannot continue working. You're in a period of authorized stay, so you can stay in the country, but you can't work. Option A, as we've discussed earlier, please upgrade to premium so you never get to the 240 days. Option B is spend more money and file another extension by the 240-day mark, and that will give you a fresh 240 days. But that's a long time to go without a valid I-94.
We don't understand why you should be there at all. Emily, Himanshu has this question that if the company let go people recently, can they not file a green card? Is there a 90-day rule for it?
There are restrictions on that in the event that a layoff occurred in the same job at the same location. The company may be restricted from filing the labor certification unless they take some additional steps. Because how can they say that there's a shortage of qualified, able, and willing U.S. workers for the job if they just laid off a bunch of qualified, willing, and able U.S. workers for the job? So they would have to actually go to those employees and determine whether they're qualified. Even if it's a different job, if it's still similar enough, it can create an issue for getting the perm approved.
My H1B extension is pending. Can I now move to a different company?
Well, I think it depends on whether the I-94 has expired or not. If it has not, you could file a transfer because you don't need the extension at that point. You're filing the transfer based on your underlying petition that's already approved. If your I-94 is already expired, generally what happens is you've got your pending extension, you get the great job offer, you file a transfer, you move to the other company. Guess what that company is going to do? The first company is going to withdraw your pending extension, and the bridge collapses between your valid I-94 and the date that the new transfer was filed. That means a very high chance that your new transfer is going to be approved without an I-94. That's the exact thing that happened to one of my cases literally yesterday. So I would, again, advise if you're filing an extension, do it early so you don't get into that situation. If you are going to file a transfer, probably not the best plan to file it while you've got an extension pending.
Raju has this question. My H1B is not approved. He didn't elaborate whether it's H1B extension, transfer, or the new quota. Can I just go and get a day one CPT and start working? Is it legal? I want you to explain very clearly, Emily, that if a person has moved, has used up the OPT period, and now he's joining another master's degree and getting a CPT, what are the risks associated with it? And I want to explain after that how the universities, some of the not so good universities are practicing.
Right, so the general rule is you cannot get CPT when you're in a graduate program until you've spent 1 year in your studies. Then you may be eligible for CPT. There is an exception to that says if immediate participation is required, then CPT from the beginning, before you meet the 1 year requirement, may be given. It may be authorized by the school. Now, there are schools that are trying to fall into that exception and are authorizing CPT. However, what we're finding is in the event that you, say, finished your master's degree in one field, you've done your OPT, 12 months of it, didn't get the H1B selected, so your method of continuing to stay in the country is to re-enroll in school. Nothing wrong with that. However, the purpose of being here is to be in school. It's not to work. People are using CPT as a way to be a student forever and get free work authorization. So the rule is that once you've used up 12 months of OPT time, you are not eligible for another round of practical training unless you go up a degree level. So if you're going back to school at the same degree level and you're getting this day one CPT, it is very likely not authorized, even though you've been authorized, even though you've got the I-20, even though your school said, yes, this is fine. We're finding that USCIS is questioning it when you later go for the change of status. I've seen at least 5 requests for evidence in the last week on that exact issue. So, and now on top of that, we have the new danger of the unlawful presence memo for students. Now, what they're saying in the request for evidence is that if you use your OPT and you went back to school at the same level and now you're on CPT, that is a violation of F1 status. Add the new memo that says your violation of status means you are unlawfully present from the day the violation started.
Not when the day they decided.
Right. So if you
That's
did
not good.
CPT a year ago and have been on it this whole time, and now USCIS issues a decision saying that's a violation of status, you've been unlawfully present for the entire time you are on CPT. So of course they're going to deny your change of status. You're out of status at that point, so you have to leave. When you leave, you're going to trigger the 3 or 10-year bar. You're going to be stuck.
Then you have to go to India to get the stamping. First is you have to get the waiver for the 10-year bar, which I will be very highly suspectful they will grant it. And then afterwards you have to apply for the H1B. That's a miracle if you're going to go through that process though. We in general do not advise the day one CPTs from the beginning. And also we notice that these universities that are issuing the day one CPT assembly, they're actually conducting classes 1 or 2 days a month. So that they are actually working elsewhere. This 1 or 2 days, they come and fly and then stay there in that particular place. And practically, I don't know what they study all in 1 or 2 days, continuously, 12 hours, 24 hours, I don't know how they are studying it. We are very suspectful of those universities that are issuing day one CPTs. I've also noticed in people when they fell out of status, either their H1B extension has been denied or if their change of status has been denied, even those people are going to the universities. They are getting the day one CPTs. I don't understand how an undocumented person is being issued an I-20 with a CPT, and it's just, I can't figure it out how the university are doing it, but they are doing it.
Right. If you're in, not even in F1 status.
Yes. Your F1 status is not even granted yet.
Right. So you can get this I-20. Sure, you can get the I-20, but you have to file a change of status to F1 or go outside the country and get the F1 visa stamp. How is it the school is guiding these people and telling them that, yes, you're in F1 status and, oh, by the way, you can work with this CPT? That is not possible. You have to actually be in F1 status to be granted CPT.
There are a lot of universities that got into trouble. Silicon Valley University has been, accreditation has been taken off. I don't want to name some of the other university officials that went to jail. And a lot of the students who were going to that school got into big trouble, thousands and thousands of them. And Emily, can you explain the University of Northern New Jersey for the people so that they are aware how the things go on here?
Right. So, we saw many students who were properly enrolled in the University of Northern New Jersey. They had I-20s, they had CPT, they supposedly were taking classes, they filed their H1B petitions. Come to find out, it wasn't even a real university. It was a sting operation by ICE. They created a fake university, fake website. They enticed students to enroll in this university, gave them the easy I-20, gave them the CPT, gave them client letters to submit with their H1B, and they kept approving the H1Bs even because it was a way for them to gather more and more evidence. If you deny everything,
then they will find out what's going on.
They'll realize, oh, I shouldn't do this, it's a problem. But if they keep approving, more and more people are going to do it. It just entices more people to do it. and they gathered a lot of evidence through that process, and all those students were left in trouble.
Deportation. Some of the employers have been put in jail and all those things. Anu has a good question. Is the 485 interview mandatory if the priority date is before March of 2017, or is it if you file the application in March of 2017? It doesn't matter when your priority date is. Even if your priority date is 2008, if you file your adjustment of status after March of 2017, it is mandatory for you to go through the interview process of adjustment of status. Good questions coming in today, Emily. Is filing an I-140 for the H4 candidates allows them to continue on H4 EAD even if the H4 EAD has been taken out by the USCIS? No. Even if you have an I-140 on a H4 EAD, if the H4 EAD is being taken off, then you will not be able to continue on the H4 EAD. Emily, can you explain what's going on in the H4 EAD? We're expecting new regulations or proposed regulations in June of 2018.
Right, so yeah, that's what was on the spring regulatory agenda, and also in December, the fall agenda for USCIS Homeland Security indicated that they plan on proposing a new regulation that would restrict certain H4 spouses from obtaining employment authorization. Now, why do they say certain H4 spouses? Some people think that means that some people will be allowed to continue. My take on that is no, that is not what they mean by that. They use the term certain H4 spouses because that's the same terminology that was used when the regulation was passed that created the H4 EAD. So it's quite clear that their goal, their ultimate plan is to rescind the H4 EAD. Now, when is that going to happen? I checked today, and before any regulation can actually be published for a proposal, it first has to be submitted to the OMB, Office of Management and Budget. That review takes about 30 to 60 days, sometimes longer. This regulation has not even been submitted to the OMB yet as of today, which means it's very unlikely, in my opinion, that a proposal will actually be able to be published in June, because they haven't even started the process yet by submitting to OMB. So I expect continued delays. I do think it's coming eventually. It will go through a long process. As a reminder, once the proposed rule is issued, it does not do anything. It's just a proposal. So H4 EADs are still valid. You can still file it. USCIS still has to approve them. The only time it stops is when we finish the entire notice and comment period, it goes to OMB again, then a final rule is published, and then the effective date actually takes effect, and there's no lawsuit. Then, and only then, would a rule be final that could impact those with the H4 EAD. Now, will they wipe out all of them, even if you already have one? Or is it just going to be new people won't be able to apply? We don't know. That will be likely in the proposal, and we'll be able to comment on that aspect of it. But based on how they've dealt with this situation in the past, we would expect that those that have a valid H4 EAD on the day the final rule takes effect most likely should be allowed to continue the H4 EAD until it expires, and they just won't be able to renew it. And those that have not yet filed for one won't be able to file at that point. That's speculation, but that's kind of what we expect.
Don't boil your bread with the next question I'm going to ask you, Emily. Being a Kroger, this is it. Is University of Houston accredited? And is it eligible for the masters? We both
Go
are
Cougs.
we both are Krugers. We both have studied in University of Houston. That's the best university in the world, guys. That's where we both are from. So obviously no problem with University of Houston. No problem with master's degree and advanced degree in there. Here is Ravi has a good interesting question that the spouse's F2 visa has been rejected twice. Is it better to apply again an F2 visa? I am in the cap right now, or is it better for me to get the H1B approval and then after the H1B approved, should I get the H4? Obviously, don't try the F2 visa again, particularly in a cap. I'll be very surprised if they issue it. If you keep on applying like this and getting the rejection, you're going to have a negative consequences when the H4 is going to be applied. Also, the majority of the reasons why the F2 visa is rejected, because they think so that the person has an intent to immigrate into United States and not leave the United States. That's the major reason why the F2 visa is being rejected. But when it comes to the H4, that is not going to be the reason at all for rejecting. Even if the consular officer thinks that the H4 person is not going to come back, they're going to settle in United States and get the green card, they cannot reject the H4 visa based on that. So it's going to be very good for your tactic purposes to not apply for the F2 visa again right now. Wait until you get the H1 approval, then approach for the H4.
All right. If someone has an approved I-140 but their employer's not sharing any of the documentation, is it possible to get I-140 document?
For all those people who don't have an I-140, it's called FOIA, Freedom of Information Act. You can Google it, you can get the form, FOIA USCIS form. You can file a Freedom of Information. You will get the file of the I-140 that has all the information, including your labor certification, your I-140 application. When your I-140 has been approved, if by any chance if the I-140 has been withdrawn, it gives you the withdrawn date. If you don't have an I-140 approval, if by any chance you don't have the labor certification approval, we strongly recommend to file a Freedom of Information Act. It's taking approximately about 3 or 4 months for you to get that information. Do you require a lawyer for it? Most probably not, because it's kind of fairly simple. You can't make a mess. If by any chance you get the denial of the request, you can always file it too. So I would recommend that to file a Freedom of Information Act to get that information.
All right. We have a question about filing a transfer and potential missing paycheck at the time of filing. Can that cause a problem? Yes, it can. Every time you file an application with USCIS, whether it's a transfer, extension, amendment, or yeah, I guess that's all of them. Anytime you file, you always have to prove that on the day of filing you are in valid status, and up to the date of filing you properly maintained that prior status, whatever it was. So if you are in H1B status and you're filing a transfer, amendment, extension, or even a change of status to something else, you always have to provide the most recent pay statements to document your maintenance of status. The only time that does not apply would be in the event where the grace period applies. So since January 2017, we have a new regulation that allows a 60-day grace period in between jobs in the event that you're changing employers. So if your I-94 has not expired and you lose your job a month ago, you can still file a transfer even though you haven't been paid during that month. And your transfer can still be approved with the new I-94 based on this grace period regulation.
Angad has a question with regards to his state status states that a case has been transferred to the new office jurisdiction. What does this mean? What does this mean is that right now there are two service centers. One is Vermont Service Center, one is California Service Center. Sometimes what happens, there are more officers in Vermont Service Center or sometimes in California Service, depending on the load of the H1B, depending on the load of the officers. The California Service Center H1Bs could be transferred to the Vermont Service Center, or if the Vermont Service Center's load is very high, they're going to transfer the H1B applications to the California Service Center. That goes on very routinely. I don't think so you have to worry anything about it. Just continue as you are, nothing to worry about that it's been transferred from one service center to another service center. It won't make much difference for you. Okay,
we had a question about how long it takes to get an LCA certified these days. First, the LCA process is done by the Department of Labor. USCIS is not involved in it. Once the LCA is submitted, it usually takes about 7 calendar days to get that certified.
One other thing is that my H1B is pending in the new quota. Can I travel to India right now and come back? I'll come back on F1. Can I do that?
Well, it will abandon your change of status if you requested a change of status. And on top of that, you may not be allowed back in because when you're trying to enter on a student visa, the purpose of the student visa is to study. However, you've already given an indication that you plan to work based on your pending H1B. So those two intentions conflict, and you could actually be denied entry and when you're trying to come back on the student visa. Also, I've heard about this quite a number of times. I've seen it happen last year, and now I'm hearing it's again a problem this year. For those that purposefully filed the H1B for consular processing because they knew they were going to be traveling over the summer, USCIS somehow still gives the information to SEVIS, who updates the SEVP portal, saying that now you're in the cap gap. Well, if you filed consular processing, you're not eligible for the cap gap, so that's a mistake. And that mistake could ultimately lead to your SEVIS record being terminated when the H1B gets approved, and then how are you going to come back on an F1 when your SEVIS record is terminated? I've seen that happen with people last year, and I got a comment on my blog just today about that happening to someone else. So if you did file for consular processing and it looks like your SEVIS record has been updated with the cap gap, I would recommend that you contact your DSO right away to make sure that gets corrected before you do anything else. It seems to be a glitch in the system.
Second, if we do if we plan to do PhD, can we get an OPT? I have completed my master's degree. Now I'm enrolling in PhD. After completing the PhD, can I get an OPT again?
Yes, you should be eligible for 1 year of OPT as long as you did not use 1 year of CPT during the PhD.
Is EB2 and EB3 movements, a lot of people are a little bit confused about it, but let me explain it. Sometimes EB3 might be more advanced than EB2, sometimes EB2 can be more advanced. At this point of time, EB2 is advanced than EB3. There is a chance that EB3 might advance faster than EB2. If I were you at this point of time, I'm not going to act anything. I'll keep watching more thoroughly. And please come to our weekly live updates, and we will update you if it is necessary at any point of time for you to move into EB3. There are a lot of times you can use the same labor certification to get into EB3. You might want to check with your lawyer if you want to, without submitting another labor certification.
All right, here's one. I need to go to India for my vacation.
Well, you don't need Red Indian and PC, buddy. I mean, you want to go to India. You don't need to come to an immigration lawyer's thing. We are here to help you to stay in this country. You want to go to your home country, you can go to get your passport and go to a home country. We are not there to help you out for that.
Now, in their defense, the actual question was, if I'm planning a vacation in India, can I go to Mexico or Canada for my visa stamping instead of going in India?
Under certain, first is Mexico, unless you have gotten a visa before from Mexico, they're not allowing you to go to Mexico. You can go to Canada for getting the visa stamping. We in general do not recommend going to Canada unless you have a master's degree in United States. The reason why we don't recommend going to Mexico or Canada without a master's degree in the United States is because if you have a degree in India, or if you have any other qualifications in India, the US consulate in India knows very much about the universities there compared to the US consulates in Canada or Mexico. We in general are discouraging people right now to go to Mexico and Canada. I would rather want them to go to the home country because we are seeing a lot of problems in Mexico. There's not a great advantage in going to Canada and Mexico. It's better that you get stuck in India rather than getting stuck in Mexico or Canada where it's hard for you to survive there.
All right, Satish has a question that I've literally received probably 50 times a day for the last month on my blog.
I'm sorry?
Satish. So the issue is for those that were selected in the lottery for the H1B cap, received their receipt notices. When they go on to USCIS.gov and type in their receipt number, the online case status is giving them a validation error, which makes everybody think something's wrong with my case. Why isn't it in there? Why isn't the status updated? Completely normal. So don't worry about it. That is happening with so many people right now. The reason for it is there's kind of two parts to the data entry process. So they may have completed data entry enough to get you your receipt, but they've not finished entering all the data into the system that provides the case status updates. So give it about 30 days. It should be updated. I heard yesterday that a number of cases that were previously showing that error are now working, but going forward, if you see that error, it's not really a problem. It just means they haven't gotten to that data entry point where it becomes available. Now there is a My USCIS portal where you can sign up for an account and enter it, and apparently I've heard that that allows you to actually see the case status even if the regular case status is not showing up. I've not used that portal. It makes me a little nervous, but because of the disclaimer that's on there that says any information you submit can be used against you. So I'm a little skeptical of that portal, but even if you use just the regular USCIS case status website, don't worry if you get that validation error. It's nothing to be concerned
Emily,
about.
with regards to the duplicate filings, I don't know, I'm trying to collect the data right now. I'm asking your help on that. We do conduct a daily conference call for Red Union PC. If you want to get into the daily conference calls where you can ask questions, whether it's going to be me or some other lawyer from our office, you can find that information at rnlawgroup.com. With the duplicate filings, Emily, you have advocated so many times not to file duplicate applications. And RN Law Group website also has said so many times not to file the duplicate applications. What I got the information right now is that for all those people who filed duplicate applications, I still need the validation, is that all of them got selected.
It seems to be what I'm hearing on the blog as well, is people are posting that
if they filed three of them and 3 of them got selected.
Yeah.
Does it seems to be a pattern that the USCIS, based on the memo issued before, that they're actually tracking these people and they want to take action on these people? That's the reason why their H1B has been selected?
Yeah, that's my guess, is they're just gathering evidence.
And if anybody has filed duplicate applications, here is what I will tell you guys. You need to contact an immigration lawyer and, if possible, a criminal lawyer immediately. There are people who will tell me, Emily, that no, there's 2 different employers, there are 2 different jobs. We do not trust that at all. And the USCIS does not trust that at all. The USCIS will, with the investigation agency of Immigration Custom Enforcement, probably will interrogate the employers, the employee, to see if there is anything that they have tried to circumvent the lottery process, which according to us, if you file a duplicate application 99.9% of the time, yes, that's for the duplicate, it's a circumventing of the lottery process though. I would recommend. And Emily, any comments on that?
Well, what if you withdraw the one that you don't need?
That's not enough, because the USCIS is still going to look into if you have filed for the duplicate application, if you were involving in collaborating or conspiring to circumvent the lottery process. They might still go after you and both the employers. Sometimes one employer probably is an innocent guy, but he might still be in trouble because he doesn't know that the other person has filed an application. But still, if you have filed duplicate application, this is the right time for you to contact an immigration lawyer, and please tell your employers to contact the criminal lawyer too. Because we have told many times, do not file duplicate applications.
Yep. And withdrawal does not make it go away.
No, it does not. And we have also noticed that for those people who have filed duplicate applications in the previous year, we have seen in some cases the USCIS is now coming back and revoking the duplicate application that was filed before. So it's not that the H1B is approved, you are safe, you might still be in trouble. We have advised many times, but if by any chance you have done that activity right now, you need to consult with a lawyer and sit down one-on-one, and maybe a criminal lawyer too. What is the meaning of duplicate application, Emily?
Well, I would say The meaning of duplicate application is one employee being sponsored by multiple companies, same company, different company, it doesn't matter. They could all ultimately be determined to be duplicate applications. So just because it's different companies, just because it's different client sites, just because it's the same client site but you use different attorneys, all of that is just a way to get around the lottery, and it's a problem. So yes, it's a duplicate. Even if you don't call it a duplicate under, because they're a little bit different, USCIS will take the stance.
If, let's say, for example, the employee name is Srinivas Rao Tottaguda. If Srinivas Rao Tottaguda's H1B application was being filed by two employers, we consider that as a duplicate application.
Yeah, it's quite rare in our experience for two different companies to be willing to sponsor the same person who clearly doesn't work for one of them on the OPT or whatever their current status is. It's not that easy to find a job and have an employer to sponsor you. It's very expensive for the employer. That's kind of their last hope, is to sponsor someone for an H1B. So we find it very unlikely that an employer is going to be willing to file an H1B in April for someone who can't start working for them until October. It just doesn't really happen that way.
Is the immigration reform bill on the agenda of the Congress Assembly?
It definitely not. It all seems to be going downhill yet again. There was a farm bill where they were trying to get DACA in there. We're still trying to get this discharge petition in the Queen of the Hill, whatever you want to call it. Nothing's moving. No one seems to care. No one, it's all for political purposes at this point, and they all blame Trump, saying he's not going to sign it, so we're not going to bother with it. Congress just is not doing its job.
Have you seen any applications for the client location STEM extension people, RFEs, in the H1B, where they're in the STEM extension, they're working at the client side? Have you seen any RFEs in the new product?
Based on the memo, or you can even call it a memo, the website update, no. I have seen where they've asked for the 6-month validation reports. Some have asked for the 983 form itself. But as far as specifically mentioning that the USCIS website says no third-party placement, I've not seen that yet.
Anything else, Emily?
I think we've pretty much covered everything.
Thank you for coming on Tuesday Live. The next Tuesday Live will be 5 p.m. Central Time. Every Tuesday we're going to be presenting immigration questions. It's going to be next Tuesday at 5 p.m. Thank you guys for coming and tuning to Radio New NPC.
Thank you.